Greetings to respected dignitaries and all impaneled advocates of Delhi High Court Legal Services Committee. We are grateful for your presence here today. The program today is an attempt to upscale the personal question of all the impaneled advocates of Delhi High Court Legal Services Committee. And it is because of you advocates that our committee is able to discharge its function efficiently. For today's capacity building program, we have amongst us Mr. Siddharth Agarwal, Senior Advocate. I would request Mr. Arul Verma, Additional District and Session Judge and Learned Secretary Dhclsc, to kindly present a pottage plant and a memento to serve as a token of gratitude. Thank you, sir. Mr. Siddharth Agarwal is an alumni of NLSIU Bangalore and has been designated as a senior advocate by the Honorable High Court in the year 2021. He has been practicing law for over 25 years in all tiers of the judiciary. Sir was appointed as a counsel for representing the Delhi Police before Justice J.S. Verma Committee and Justice Usha Mehra Commission of Inquiry constituted in the wake of the Nirbhaya incident. Mr. Siddharth was appointed as a counsel for the Justice Retired T.K. Jain Inquiry Committee appointed by the Honorable Supreme Court to examine the alleged illegalities in the arrest and prosecution of Dr. Nambi Narayan and other scientists in connection with ISRO espionage case. Additionally, Sir is also frequently appointed as amicus curiae by the Honorable Supreme Court and Honorable High Court of Delhi in various matters. I would now request Mr. Arul Verma, Learned Secretary, to kindly address this gathering with his introductory note. Over to you, sir.
Good evening, ladies and gentlemen. Today we embark on the journey to enhance our professional prowess. To be proficient in any field, especially in our field, it is imperative that we revisit on a continual basis the rudimentary principles and canons of law. And we also need to be abreast of all the latest developments that have been ushered. So today's topic is appreciation of electronic evidence. It's a step in this regard. Now, there are a litany of judgments on this topic from Anwar versus Bashir, Navjot Sandhu, Sonu versus State of Haryana, and Arjun Pandit Rao, and they all have discussed and stated and restated the positions of law, and the observations oscillate between extremes at times. So, for example, some say that you can lead secondary evidence with respect to a electronic record under Section 63 and 65 of the Evidence Act, whereas at times they say that no, Section 65A and 65B is a code in itself. So then also there's an issue that at what stage can a 65B application be filed? Can it be filed later on when the trial has commenced, or it has necessarily or mandatorily to be filed at the time of filing of a charge sheet? And what does one do who seeks to adduce evidence if he is not in possession of that electronic device or equipment? So there are issues, and even though Arjun Pandit Rao has clarified the conundrum, but some issues still linger. And now to give an insight into this complex web of law and technology, we have with us a renowned senior advocate, Shri Siddharth Agarwal, and Shelly has already introduced all of you to him. But I want to add, because I met one of his juniors also, and what he had to say is that sir is the best in criminal law at present in the country. That's what people have to say about you. And not only that, I think keeping in perspective his passion for social causes, the Honorable Delhi High Court appointed him as an amicus curiae to look into or to ameliorate the conditions of police constables, of Delhi police constables. I think that happened last year. So you all know Delhi police constables, they work overtime. We see them on the street, so sometimes their working hours stretch up to say 36 hours. So sir is, I congratulate him for, handling this noble endeavor that he's been assigned with, entrusted with. And one of his juniors has also said that, he's spoken about his devotion and his zeal. So irrespective of the amount, the brief, the fees that he gets, whether it's lakhs or thousands, or even if he does it pro bono, sir will, he will burn the midnight oil, and he will literally keep himself awake to do justice to the matter on the next day. So, all this tells us that he's a man who's got his heart in the right place. And therefore, sir, it's an honor to welcome you to this function, and I request you to please, everybody, kindly welcome him with a round of applause. And sir, the floor is yours.
Hi everybody. First of all, thank you for these kind words. But I really do hope that some of them were true, because I see myself as somebody who has been part of this panel. I've assisted as part of the Delhi High Court Legal Services panel for a few years, and I didn't realize that we were going to be in such a formal setting with an auditorium, etc. Otherwise, I would have definitely been better dressed and better prepared. But I came here to share perspectives, and I think that's, as lawyers, as law students, as students of the law, that's all that we can do with each other, is to share perspective. There is no right answer or wrong answer in our profession. All of you are competent and independent professionals in your own right. You don't need anybody else to guide you or tell you in any which way. I think the purpose with which I come here is to try and place before you what I have understood, and then in the process of discussion in this particular program, we can see how we can refine each other's understanding, and maybe we will come closer to certain answers, and maybe we will leave each other with more questions. We don't know, but that's the journey of a student of law. So thank you so much to the committee and to the member secretary for inviting me and having me here. So without further ado, let's just look at the topic by itself. It's appreciation of electronic evidence, and it's amazing that what we have now reduced ourselves over the last 24 odd years, before when 65A, 65B have come into our lives, is to reduce the concept of electronic evidence to a mathematical formula and a question. Certificate hai, admissible. Certificate nahi hai, inadmissible. And that, unfortunately, is because a lot of our time in courts has gone into this one question of, is certificate compulsory or not? And that has been, and it's an important question, that has been the question which courts have sought to answer, and now, as was pointed out, has been settled. But there are various nuances irrespective of the fact, even if there is a certificate. How do you appreciate electronic evidence? Because appreciation is not really about the admissibility portion of it. It really comes down to, after that evidence is done and after the certificate has been given, let us assume, does it automatically mean that the electronic record must be accepted by the court, must be acted upon by the court as something which is gospel? So there is a slight digression I will make towards the end of the presentation, which is to get into issues of electronic evidence which don't necessarily deal with appreciation in a trial format necessarily, but which have an impact on the cases that are likely to come up. Small things like Can you force an accused to give his password? Can you force an accused to give biometric access to his phone or to his laptop or to other devices? What happens to such evidence which is obtained from that particular device? These and others are already engaging the courts right now, and this is something, this as topics which will be natural extensions to how we look at electronic evidence in the future. All of you are aware, two kinds of classes of evidence in terms of oral and documentary. But the interesting thing about electronic records is that electronic records are actually not documents. And I think this is something which, if we look at the provision, both in terms of Section 3 of the Evidence Act, because what it now says is documents will include electronic records. And the interesting bit when we look at 65B is that if certain conditions are specified, then an electronic record will be deemed to be a document. I think that this distinction, the legislature, the parliament could have very well said documents or electronic records are documents. Nothing more needed to be done. Our understanding of oral evidence and documentary evidence would have gone straight away into the format of there is a documentary regime, electronic records are documents, so 63 applies, 65 applies, everything that you can do with a document, you could then do with an electronic record. But in reality, what electronic records get defined as, which is in the IT Act, come into our lives with reference to 65A and 65B, which is deeming of information which is contained in an electronic record to also be a document, subject to compliance with certain conditions. And those conditions, as you know, 65B4 says there is a certificate, but I want us to focus away from the fact that there is a certificate. But what does that certificate contain? What should it contain? Who should it be issued by? What should be the kind of insight that that person must have and bring to the court so that the court can feel confident that the material that is coming in front of me is something which is capable of being acted upon. So what that certificate does and the kind of requirements it has will do that. So let me come back and just to refresh ourselves, there are provisions within the Indian Evidence Act as to how documents had to be done. Generally speaking, original, primary, no oral evidence where document is there or is capable of being given. Certain circumstances where you can lead secondary evidence, and those circumstances are also circumscribed by what kind of secondary evidence can be led in what kind of document. This position, let us look at what was the scenario prior to the Information Technology Act. So you had, I wouldn't say the heading of this slide is slightly wrong, it's slightly wider because it talks about electronic evidence. But the first set of challenges were, let us say, in the context of photographs, in the context of audio tapes or videotapes, things which were not usual in the course of human conduct in courts. And that came up for consideration in Ram Singh versus Colonel Ram Singh, celebrated decision which everybody is aware of. And back in 1985, they put down a certain set of tests. And if you look at these tests, you will realize how intermeshed the issues of relevance and admissibility have been made in Ram Singh. So for example, person seeking to prove such a recording was required to first establish the relevance of such recording. Voice contained in the recording was required to be identified by a competent witness. Person seeking to rely on such audio recording was required to establish that the voice should be clear and audible, should not be lost or distorted by other sounds and disturbances. Accuracy of the recording had to be established by a competent witness in order to eliminate the possibility of tampering, and chain of custody of the medium containing the audio recording had to be established. So if you look at these 5 principles, almost all of them really deal with the probative value or the veracity or the ability of a court to rely on it. Don't necessarily have something to do with admissibility from that point of view. But what the court was conscious of was that these are now kinds of material which are capable of being distorted. It is difficult. It is relatively easier when a document is distorted, where physical original document is in front of you, versus seeing a videotape or an audio recording. And we are still talking about physical devices. These are not electronic records in that sense. But a photograph which had a negative. So the negative was the proof of the photograph. The photograph by itself was secondary. And that's one of the definitions or the kinds of secondary evidence which is available. So back from 1985, the issue of how do I ensure that the material that is placed before me is something which is capable of being acted upon. I have the confidence as a court that sort of crept into our decision making on will I open the gateway. Admissibility is the gateway question. Will I open the gateway to even allow this to happen? This is something which is interesting, at least when I came across it in one of the matters that we were doing. It is generally thought that 65B is this novel piece of legal architecture that came about when the Information Technology Act came. And we found that actually that's not correct. So 65B has marked similarity to 138 capital C of the Customs Act 1962, which was inserted in 1988, regarding admissibility of microfilms, facsimile, computer printouts, etc. So it deals with computer printouts back in 1988. And 138C talks about, notwithstanding anything contained in any other law for the time being in force, a microfilm of a document or the reproduction of the image or images embodied in such microfilm, a facsimile copy of the document, a statement contained in a document and included in the printed material, which is hereinafter referred to as a computer printout, if the conditions mentioned in subsection 2 and other provisions contained in this section are satisfied in relation to the statement and the computer in question, shall be deemed to be also a document for the purposes of this Act. Now, very similar language to 65B or 65A and B that you will find. And what were these conditions? Subclause 4 of 138C. In any proceeding under this Act and the rules made thereunder, where it is desired to give a statement in evidence by virtue of this section, a certificate doing any of the following things: identifying the document, giving particulars of the device, dealing with the matters mentioned in subclause 2, and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device. So you will find the seeds of what we finally see in 65B available and applicable in our legal regime in the statutory format from 1988 itself. Similarly, there was, I think even in the Excise Act, there's a similar provision like Customs Act, and you can look that up. We can provide that section. So 65B, the requirement of a certificate and what we were dealing with was available. Unfortunately, we haven't come across any case law to see how 138C has been interpreted, how has the requirement of this certification been interpreted, etc. From an international perspective, 65B was also based largely on Section 69 of the Police and Criminal Evidence Act, which is called PACE in the UK. But, and this is where the life comes a full circle. We are grappling with 65B, and UK has repealed PACE. So the requirement of a 65B like certification and the specific positions in terms of statute saying, oh, I must have A, B, C, D given, which we took from the UK, is something that does not emanate in the UK now. And UK has gone back or moved forward to a position to say that if a person who is in custody comes and gives it, I will appreciate it like I would in the case of a document. So the old common law principles or the issues or the kind of assessment that had been made is now being made with reference to electronic records. Obviously it would be different. But this very pedantic approach of putting I must have a certificate, that certificate must say 1, 2, 3, 4, nobody understands what that certificate is. One nodal officer will come and give that certificate. Neither he knows what it is, nor the policeman knows what it is, the lawyer doesn't know what it is, and the judge doesn't advert to what the certificate is, but we are all happy that the electronic record that has come into my court is somehow, it has been sanitized. Whatever problems there were have now gone. So this issue of how do I get to the substance of electronic evidence and not just make it about is there a certificate or not is something that I will at least invite each one of you in your own spheres to look at. Very quickly, the journey of the certification. The first judgment which actually was delivered on this aspect in India was the Delhi High Court. While the Supreme Court is put up on the screen there as a citation, was the Delhi High Court decision, where Justice Usha Mehra and Justice Pradeep Nandrajog, in a judgment written by Justice Nandrajog, accepted the position that 65B requirement of a certification or a document as a certificate was not mandatory. But the requirements of what that certificate or what the person must come and depose to is what is given in 65B4. So as long as you have some evidence, whether it is oral or documentary, on the aspects of yes, there is a computer device, it is in my control, it is error-free during the relevant period, this is a printout of that particular computer device and I am now presenting it. As long as somebody comes and says it even, it is good enough and we must accept it. They also said it need not even be in chief examination because you can cross. So if a person is coming and saying, I have authenticated it, I've said this is true and correct, then the onus shifts on the defense and the defense must do a cross-examination. That position was then upheld by the Supreme Court in Dhclsc in 2005. And this is, we must also see how things play out in court. The first test case on this issue happened to be a criminal matter, happened to be a matter of moment. This was the Parliament attack case. The evidence in question was important. So sometimes the issue of the impact of that evidence has a softer bearing on the interpretation that was done. The interpretation is based on a decision of the House of Lords, I think, which spoke about the same position of, yes, I don't need a certificate for it. Navjot Sandhu was then overturned by the Supreme Court in Anwar Bashir, an election petition. An election petition where the nature of interpretation, because it's Evidence Act, it will apply equally to both. But the kind of consideration which is bestowed in an election petition is slightly different. And in this context, in Anwar Bashir, they said no, 65B has to be read with 65A. It is a deeming provision. And it says, I am now creating, I'm taking the liberty of paraphrasing, I'm taking the liberty of adding on my analysis to that, so please pardon me for that. That 65A tells you that there is a new class of material called electronic evidence which will be deemed as a document if 65B etc. is done. So 65A and B combined is a self-contained code. It cannot be done in any other manner because now the law prescribes only this manner. And hence on that basis, Anwar Bashir came up. Tommaso Bruno, oral evidence sought to be given on the in relation to a particular, I think, this was a video or something, and that was disallowed, saying no secondary evidence can be taken. Sonu, proof of electronic records is a matter of mode of proof and must follow rules of fair play as envisaged in Venkatadal accounts. A very interesting point. because while we are dealing with certification, this judgment of Sonu, Haryana and reliance on Venkatachala Gounder will lead you to another issue. And when you argue appeals, etc., as legal aid counsel, something that you have to be, aware of. What happens if an objection has not been taken regarding 65B during trial? So witness comes, say nodal officer of one of the telecom companies or something else, even a private person saying this is an email, and the trial court lawyer does not take an objection at the time when the document is tendered. Venkatachala Gounder says there are two kinds of documents, hence two kinds of objections. If the document is inherently inadmissible, it makes no difference whether you take the objection or you don't take the objection. So like if I come and say this is a 161 statement and I seek to exhibit it and the judge even puts a mark on it and I don't take an objection on 162 at that time, makes no difference. The document by itself is inherently inadmissible. Law makes it inadmissible. So you don't need to take an objection. There are others on mode of proof, for example. You say, I did not take the objection. There, if you don't take the objection, Gounder says, well, the purpose of taking an objection is that you are putting the other side to notice. That, sir, there is a better way of proving this document. You are not doing that. I am putting you to notice right now, so that the other side can rectify that error or that mistake or that loophole in the course of trial. But you can't steal a march over the other side by not, when the plaintiff or the complainant or the prosecution tenders a document and you don't raise an objection, you can't raise it at the end stage. And this is the analysis in Gounder. What Sonu seems to indicate is that 65B is a latter kind of an objection, that you must take it. That if you don't take it, then nothing can be done, it can't be done later on. This has an interplay on multiple appeals, but in how you actually say that whether the document is going to be admissible or not. It also then has an issue of what stage the document can come into my trial. But most importantly, this, according to me, is contrary to Anwar Bashir. If the entire analysis of Anwar Bashir and subsequently now Arjun Pandit Rao will be that it is the existence of a certificate with 1, 2, 3 and 4 things written there which make this electronic record and deem it to be a document, then to say that whether I take an objection or I don't take an objection is going to determine the nature of that document would not be correct. So please do look at Sonu and how Sonu deals with it. In Sonu, an application lies pending in the Supreme Court to clarify whether it is a prospective position in law or retrospective. Then came Shafi Mohammed, which disagreed with Anwar and put this position of yes, 63 and 65 are available. So we are now back to another incarnation of Navjot Sandhu. And all of this then came to 3 judges in Arjun Pandit Rao, which affirmed Anwar and overruled Shafi. And the limited exception to the mandatory nature of the 65B certificate carved out was in cases where the person relying upon the electronic record was not in a position to procure that certificate. The device, etc. is not there available. But please consider this, as I said, as one question, is the certificate mandatory? I think that question need not detain us. The answer is clear, yes, certificate should be there. But when we argue anything, whether it's on the side of complainants, prosecution, defense, the understanding of that certificate of 65B4 is, who can give that certificate? What should that certificate contain? And the requirement of the defense then to cross-examine on those aspects, because once you have a certificate which says this, then you have to displace it with your questions and the answers that you get about that. So if a nodal officer who has absolutely no idea about the way in which the computer system is kept, has absolutely no idea about where it is whether it's on the cloud, whether it's in a particular city in the country, and he is or she is coming and giving evidence on that aspect. These are all aspects which can be and should be cross-examined and then brought out to say that the certification, even though there is deficient, does not meet the standard of what 65B warrants. And if 65B is not met, not on the form, the certification is a form, but on the substance, then you are entitled to say that 65B is not complied with. And this is the sharing of perspectives continued on an experiential basis. All of you have dealt with cases where you will find there are different kinds of problems in the printout that have been given. The columns are different, the numbers are different. Sometimes there's an issue where location is not put there. So all of these aspects, this is where on the substance of it, cross-examination and leading of evidence becomes critical. You can't then just rely upon the fact that, oh, there's a certification or the absence thereof. So crucial to cross-examine witnesses to prove certificates on identification of the electronic record or device, technical competence of that person to describe that device and process of data collection, manner of production of information contained in the electronic record into the form produced in court, usage of the electronic device to be shown as regularly in ordinary course to share information, proper operation of the device in question, and glitches in the data if produced. There are times when entries are repeated, there are times when dates are skipped, there are times when you'll find 15th of the month, all odd numbers put in certain way, and then suddenly after that even numbers come in. Now all of these, because they are the product of a computer resource, may have explanations and legitimate explanations for the person who is leading them. But if you wish to rely upon these glitches, then you must ask those questions and establish that these are actually in fact a problem with the computer system and the record, and not just something that you're taking advantage of at the end stage. Because if it is going to be just used as, look here, there are double entries on these 5 things, it's not going to necessarily move the court to say, yes, I must debunk the entire evidence because there seem to be some double entries and some kind of computer errors. Examples of instances that at least we've come across in various cases. Let's say 65B certificate not issued, not produced contemporaneously during investigation. The witness has left his job. He has gone into some other company, some other job. 10 years later, when he comes into the witness box, he produces a 65B saying, I have just got this today. So whether it is compliant with 65B is one part, but what kind of appreciation can somebody give to that kind of a certificate? Random itemization without chronology in case of call detail records. Differences in call records for CDRs obtained on multiple occasions for same month. Same investigating officer asks the same utility, whether it's one service provider or the other, please give me the call detail records of this number for the month of July so and so. He receives one which has 25 items. 15 days later, for some other purpose, he asks for 3 months, which includes that month. He now gets 10 entries. These are all real cases where, and I'm saying you will have examples of these kind yourself. How do we ensure that courts get into this aspect of appreciation above and beyond the issue of is the certificate there or not? Information gaps in CDRs, as I said, days not there, weeks not there. Manual intervention to electronic records. CDR charts manipulated or seized electronic devices turned on or operated after seizure. Seizure memo done, seizure of the phone, etc. done. The device is apparently lying in the Malkhana, but when the CFSM report comes or the GEQD report comes, it shows it was switched on 15 times from the time that it was seized to the time it has been produced in court. These aspects, it is important to bring out in the form of evidence, mostly through cross-examination, in order to be able to at least bring forth the issue of, is this data, is this material capable of being relied upon or not? Now, this is my recommendation for you to consider. See, when we deal with electronic records, there are electronic records which are lying with you and me. Our phones are writing messages to each other, we are sending emails, etc. And then there are electronic records which are being generated and kept in the context of what I would say public utilities. Cellular providers, banks, electricity companies, so on and so forth. Typically, and I think this is my recommendation, there is a difference in grade of data that comes from such an entity versus something that comes from private hands. And that's not to say that data that comes from these entities cannot be manipulated, is not changed, does not have errors which are bona fide or otherwise, or that the agencies sometimes don't go above and beyond their call of duty into making things which were not there. All of this has happened, and again, that is experiential. But from a legal perspective, the fact that something comes from a public utility where data is generated and kept on an automated and an automatic format versus a situation where there is a manual intervention or a greater chance of a manual intervention, according to me, must be seen differently in terms of how we accept or how readily we accept or reject it. So data from public utilities in government servers or servers of independent third-party service providers may be normally acted upon unless shown that there are patent discrepancies or irregularities. Personal data, private messages, digital diaries, photographs, videos, on the other hand, require to be viewed with greater care and caution, since the same is fraught with greater possibilities of modification. So we'll sort of, that is on the issue of how the 65B interplay, etc. is, and what are the kind of issues that do come up. One of the issues that you'll start dealing with also is on how was electronic evidence collected, and if the safeguards of when the electronic evidence was collected, I mean not on the 65B aspects of it purely, if those safeguards are not done, then can that electronic evidence be safe to be placed reliance upon? So whether it is the issue of, so there's Karnataka High Court decision in Virender Khanna, there are issues pending before the Supreme Court on how much data should become accessible to law enforcement. The aspect which is at large and which will be at large, and we'll go back to whether it's fruits of a poisonous tree or we'll see it in the context of these are mandatory provisions, etc., comes down to this. What is the effect of non-compliance with these procedures? So CBI manual is there, it says, oh, you must deal with electronic data in a certain manner and mechanism. You're able to demonstrate that it was not done. Is it something which automatically will throw it out? Will become like a Ram Singh version of admissibility for electronic records? Or will it be something which will only be going into the probative value of can I act on this material? And these are questions which are going to be at large for us. Fruits of a poisonous tree may be argued as being inapplicable in the Indian context in view of Malkani and Puranmal. Recent decisions including Puttaswamy and Vineet Kumar, operation of which has been stayed, may be employed to argue that material sourced in contravention of law and guidelines should be eschewed from consideration. The world that we live in is where our entire footprint, our entire existence has at least a digital footprint. We are not our digital devices, but our digital devices can expose who we are. And from that point of view, issues of privacy, issues of how much can a law enforcement agency have access to your phone or to your laptop, and for what purpose, in what context, needs to get regulated by law. And all of these are issues which each one of you will argue at some point in time or the other in these matters. So yeah, so location, chat history, ledgers, banking information, everything is capable of being evidence. It's in the context of the matter in which you are. And so from a crime detection or prevention perspective, the law enforcement agency says, I want everything. A person who's being investigated says, I don't want to give anything. Where is the balance drawn? What is the ring fencing that one has to do to ensure that this is the kind of keywords or the kind of questions that a law enforcement can legitimately ask of your device and extract that data? Or is it allowed to just go through everything and say, all right, I actually was looking at a case of robbery, but I found 15 other things that this person has done, so now let me start 15 other cases against this person. This is the conundrum of, will I protect those 15 others apparently wrongdoings of that person because there is no probable cause to actually go into it and to search for it. Again, issues which will take us into other jurisdictions and their way of dealing with their legal system. So these are examples of physical surveillance, trap cases, independent witnesses. Data is available in one place, which is on your digital device. We can take clues from what is now happening with phone surveillance. So you have a time limit to it. You have to exhibit a certain kind of relevance of that particular phone number. You have to be, so these are the 419A and the review committee and all of those aspects that are happening are to try and do some sort of ring fencing into not all data that a person is generating is capable of being accessed and utilized by law enforcement, whether to investigate crime or to find out who is committing a crime at what point in time. There must be some nexus with what the investigation is in order to be able to access that. Unfortunately, in India right now, there is no or very little judicial or executive oversight to target and tailor access. It may be in the context of Telegraph Act and phone surveillance. In most other cases, there is none. Abroad, at least in the US, you'll find that it's a more warrants-based approach. The investigator, the prosecutor must come and disclose, this is what I'm looking at, this is what I expect to find. This is the material on the basis of which I believe that I will find this here. And then the court will actually open out or ring fence that particular access to say, fine, you can look at this part of the electronic footprint of this person. Question that I started with, can I be forced to give my password? Can I be forced to provide my thumbprint or a pattern which I used as locks in our phones or other personal devices as part of giving access of this particular device to law enforcement? There are two different views on this, and this is something which is again food for thought. One is obviously the issue of, is this testimonial compulsion? Am I being forced to reveal what I have only in my mind? So for example, if it's a passcode, it's not written anywhere. But am I being forced to reveal that passcode, which I don't want to do, and hence it is compulsion? Or what happens if the police comes knocking on my door and find an almirah which is locked? Two things. One, they can break it. In this case, they can break my phone. If they have any ability to use any technological devices to make sure that they are able to hack my phone open, well, that's one way of doing it. But the second is that the person can be compelled to give the key. And that's something which in the physical search bit, you'll still find reflection of that in our CRPC. From that logic, can somebody use the logic not of testimonial compulsion but of search and seizure to say that no, as the owner of the place, you are bound to give me the key, because this is only about opening it and not about what can be accessed inside. We don't know what is inside. So 20 sub clause 3, as I said, so Selvi and Kathi Kalu are relevant in this context. The important thing from a testimonial perspective is, what is allowed is for me to be told to give my biometrics or my fingerprints or etc. for purpose of comparison. Selby makes it clear that anything else beyond that is not for comparison and hence will amount to a testimonial nature of revelation. So on password, passcode and PIN, product of mind necessarily has to be communicated in a way of oral or written statement conveying facts from personal knowledge. Fingerprint and face recognition are physical characteristics, but the purpose is not for comparison but for access to further material. Functionally they are the same as passwords and they convey the same factual assertion. This is the search and seizure aspect, section 91 and 93 in CRPC, which will deal with this issue. Can a 91 order be issued against the accused? Dhclsc deals with that, and fortunately, as of now, the accused is covered in that. Can an accused be told to give his key? That question is still something which is slightly different. So yeah, this is what I would look at from an electronic evidence perspective to share with you in terms of certification, in terms of analysis, in terms of the probative value, etc. And in terms of areas which according to me are going to be something which are going to arise more and more in the context of electronic evidence. So I leave it to you for how you take it, and if there are any questions and if there's some discussion around this, we can definitely.
Thank you so much, sir, for your session. That was really informative. And now, since sir has permitted it, so if anyone has any question, they may kindly raise their hand and the mic shall follow them. Any question? Kindly raise your hand.
This is nice, that. Just a very small question. Supposing there is an audio conversation, which has only one-sided conversation, because he could record the entire conversation. It was there in camera, recorder was placed. Now, those conditions which initially do not say, they say that it should be audible, clear. It doesn't say that the entire conversation, two-way dialogue should be recorded. Similarly, for supposing there is an audio, visual, both recorded, and the videos the entire video is not done, not a very fine device. Will those evidences be still admissible? Because there is no compulsion in those judgments that it should have a both-side conversation or the entire video coverage.
Yeah, so the way I look at it, and that's why I was saying Ram Singh, the tests in Ram Singh have actually, according to me, conflated both these aspects. Admissibility, relevance, reliability, everything has gotten clubbed into one to say if these 4 or 5 tests are there, then I will act on it. So while the Supreme Court says in the context of admissibility, the test is, so if for example, let's take your example of one-sided conversation. If that conversation is to be used against another person whose voice it is not, then I really wonder in what context or what factual scenario could that become relevant for that person or against that person. A situation where the video is there but the audio is not available, again we'll go to, even if one was to say, all right, let me believe the video. So unless there's a physicality to the action, there's a slap or there's a stab or there's a gunshot, you don't need the video. The pictures there will speak. It could be just still photographs of 4 or 5 in close proximity and you would still act on that. So I think it really comes down to what is the relevance and the context of that particular material, and does it take that party's case forward to be able to say, oh, rely on this, assume there is a certificate, assume that there is clarity. Most CCTVs, for example, they have video, they don't have audio. But still, they are capable of being used as very legitimate and very important pieces of evidence in cases. So I really think it comes down to what is it that piece of evidence communicates to us. Because no piece of evidence,
Therefore, the relevancy.
no piece of evidence usually, and confession is a, I think, possible exception, can finish my case. It's like a chef who's making a meal, and each piece of evidence has an importance in that dish. And how much is it going to be your prime component of your dish, or is it going to be a garnish? Is going to be something that gives you taste? That's the nature of assessment. So I think it comes down to the factual context.
Thank you.
I think somebody here, right?
Good evening, sir. My name is Meera. Sir, there are a lot of agencies these days who are doing data extraction for a lot of our clients also. Now, in these circumstances, for a criminal trial, for example, in a defense case, if I give my mobile device, my client's mobile device to such data extraction company, now whether the 65B certificate should be given by the company, which is a third party, or by the client whose device it is, or by both?
I think it's a very important area, and I'll sort of broad base that query a little bit. I send an email to you. You forward that email to a third person. That third person takes out that email and gives a 65B on that email. Will that prove my email to you? So we have to go back to the fact that the thing about electronic records is there is no one original. There are multiple originals. I send it to this entire gathering, the one that I sent, and each one that all of you received is an original. That is the original electronic record in that sense. But the moment you forward that to somebody else, that is the only original for that. So the certification given by the third person can only be with reference to the fact that she forwarded this message to me. Now, whether the message that I sent to you is correctly reproduced there or incorrectly reproduced there, we don't know. There are, for example, there is an original device with which I recorded a conversation. I put that into my computer. From my computer, I take it onto a pen drive. That pen drive goes to my lawyer or to somebody else. That person then analyzes it and then gives their 65B certificate. My understanding, and I may be completely wrong, both technologically and legally, is there is no shortcut to going back to source. This second hand, third hand, fourth hand does not make it the correct, the original, if the original or the first recorded is what is relevant. If the purpose was what I sent to you in that email, if that is what has to be proved, then the same concept of hearsay and documentary hearsay will come in, that you must produce this email and you must then give that 65B or I must give that 65B.
Thank you, sir. In my case, I have done 65B from both, because one was producing the data, so the device was originally in my control. But the extraction company, because they extracted it,
absolutely,
and they have given me a printout, so I've taken a 65B from them as well.
Because then you're dealing with both stages.
Yes.
And then you're able to show that there is no change, hence chain of custody is there.
Yes.
Absolutely. Zishan.
So if the original is downloaded by a third person, suppose it's a company server, and the IT department guy downloads an original email between two persons,
one of whom is not available anymore. So that would constitute as primary evidence.
It's the first.
It's original.
Absolutely. So from the cloud itself, I give a printout.
Yes.
See, the electronic printout of an email is equally covered. From the cloud, I give a printout. From the cloud, I download it and put it into a pen drive. Can be done, will be done. That's how but you must be able to demonstrate that the original source was the cloud. I am in control of that cloud. Now, if you give that pen drive to me, and then now I have used that pen drive for 10 days and I am now giving a certificate on the basis of the pen drive, that is deficient. But the person who has taken it from source should be able to give you that certification.
Do we have any other questions?
One question, sir. If there is a video which is recorded from a private camera, and thereafter he took the scan disk, put it into the laptop, then take that footage into an independent pen drive, gave to the police, and police produces the 65p. So is it a deficient record, or the original person who has the ownership or the possession of that?
Sorry, when you say police produces the 65B, I don't understand.
They submit to the police the pen drive, which contains the basically footage. So whether and the police produces that it has been taken from the pen drive and submit. So the original source remain the person
with that original device. So my understanding is the original device on which that recording took place,
correct,
must be spoken to in the context of the 65B certificate.
So if
and in fact, one of the cases in Supreme Court deals with this issue, which did not deal with that original device, and hence they eschewed the portion of that evidence.
So that becomes a deficient 65B?
I would understand that as being deficient, because it's now gone through 4 iterations.
Correct.
You have absolutely no idea. But the 65B must be with reference to what generated or stored that particular information. Unless you can show, as ma'am said here, I had this, I got it extracted from somebody else, I did a 65B here, I did a 65B here, I did a 60. Each one of those stages will become relevant to your case.
But if not, will it become deficient?
My understanding, yes.
Can you share the judgment, because it's
possible? I think so.
Yeah, thank you.
Sir, can I ask one final question, sir? So here.
Sorry.
Sir, most of the matters in family court, they say although a certificate is required, but we will still look into it, even though it is deficient, because we have special powers under the Family Court Act to look into it. So how do we get over that difficulty?
Offhand, is there a provision in the Family Courts Act?
It is somebody has recorded my conversation with somebody, pass it on to somebody else, and then the fourth person is giving it to my husband and wife. They are coming to court and saying you've committed adultery. The Family Court says I have to look into it, even though deficient.
No, so from
Sorry, please go ahead. My understanding was really different. The Family Court rejects that not on the grounds of admissibility, but on the grounds of privacy.
Whether you can, not privacy. The Family Court says, the Family Court says, even though 65B, 64 is deficient, still I'll look into it, because I have the powers under Family Court Act Section 10 to look into it.
Which is why I wanted to because मेरा दखल फैमिली कोर्ट्स एक्ट के अंदर थोड़ा कम है. So from that point of view, I'm only asking, is there a provision in the Family Courts Act which does take a view different from 65?
Yes, sir. It says the court can look into any evidence irrespective of anything else. Any technical provision. So that means this entire thing goes.
I think then the way that I'm understanding the question is that the Family Court says, I will satisfy myself on whether the evidence is actionable or not, even though it may not necessarily be technically sound in terms of 65. Now the same thing would apply, let us say, for a photocopy which comes in a family matter, where a court says, no, I will believe this, even though the specifics of secondary evidence in terms of section 63 and 65 may not be fully there, but in the nature of how it has been presented, I believe it. So I think what I'm understanding is that the Family Court has the ability to keep aside technical objections, and if that is the position, then obviously 65B won't be the determinant.
It has an overriding effect on electronic evidence.
But at least, but there still should be material before the Family Court or any court for saying why I believe this to be an actionable piece of evidence, even though a certificate is not there or the correct person has not produced it. But it must, the context of the case must be something which gives the Family Court enough confidence to say that this is an actionable piece of evidence.
Thank you, sir.
And I think, and my colleague here points out, section 14 says a family court may receive as evidence any report, statement, documents, information or matter that may in its opinion assist it to deal effectually with a dispute whether or not the same would otherwise be relevant or admissible under the Indian Evidence Act. Section 14 seems to be very clear that it will not be impacted by these issues. Sir.
And the CCTV footages are exhibited. In some cases, the IOs sees the DVR as well. So, is it mandatorily required to see the DVR, or just in the certificate they mention the particulars of the DVR?
So, look at it this way. The original is the DVR. If the IO is seizing the DVR, then 65B is irrelevant. He is then seizing the DVR. He is getting the primary document. 65B is required when you are getting an imprint, a reflection of that primary. I can't get the DVR here. So, sir, I am taking it from the DVR, I am getting a 65. So, to answer your question, it is not compulsory to get the DVR. But if you get the DVR, 65B is not required. 65B is required only if you get something out of that DVR. I think I've taken too much time of the gathering.
Thank you so much, sir. Thank you for your presence, your valuable time, and your patience and positive energy. Thank you so much.
Thank you.